It's time for the Financial Crisis Talk Center with Ken Gross and David Einstandig from Thav Gross.
Credit card debt is number one. I view it as financial cancer.
40% of your gross income is going to just pay the debt service. You got no chance of getting out. I would give up my credit score to get rid of debt.
Here's your host, Ken Gross.
Welcome back to the Talk Center. This segment, the word of the day is questions, and on this segment, the topic is estate planning. So on the line, in the studio, for the answers to the questions, we've got Eric Glick from Thav Gross, estate planner for, I don't know, how old are you now, Eric? You're getting old.
I am 47.
And how many years have you been doing estate planning?
18 or 19.
That's a lot of years. So, so you've done it all. You've done the estate plans. You've seen the people through life and through death, probably.
I have.
Isn't that a morbid thought? Okay, now that's not the question. So I'm going to fire the questions away. We're going to give the answers, and then we're going to see where they go. First of all, what is an estate? Simple question, but people don't really necessarily know.
That's a relatively simple answer, too. According to Webster's dictionary, it's everything a person leaves behind after death. All of their assets. Home, life insurance.
Does it include their legacy, their reputation, what they were known for? Or is it just property?
Well, you would say for Elvis, yeah, it does.
So what will your legacy be?
My legacy?
What will my legacy be?
It'd say he worked with Ken.
There it is. Okay. All right. Now, what is an estate? Obviously, these questions are not weighted for equal time on the show. What is an estate plan?
Well, an estate plan is how we plan for an estate. So it's using the various legal documents that we've probably heard of, wills, trusts, financial powers of attorney, healthcare powers of attorney, to transition assets from the decedent to their family members.
So it takes care of it. It's what you use to take care of that estate. What you leave. Okay, now
right. The objective is to make it as easy as possible, so the surviving family members have less to worry about, one less thing to worry about.
Well, Ken, you raised a real good point when you say what's the estate, and I want to say you may think just because all of the money in a bank account is yours, and you put one of your kids on that bank account for convenience, but you really intended that when you die, it's going to go equally to your 3 kids, but the one that lives near you is on there. And if it's a joint account with rights of survivorship, that is part of your estate when you're alive, but as soon as you're dead, that's going to transfer to that one kid unless you've provided appropriately for it. So you may think that your estate is one thing, but the law is going to tell you it's something different.
I was trying to come up with an acronym for that because you jumped ahead, but that would not be JAH, that would be JA, and we're on 3-letter acronyms relative to the last segment that we talked about tax problems. But your point is well taken, but here's the question that I want that point to fall under. Why do you need an estate plan?
Well,
and what are you trying to accomplish?
Well, you're accomplishing...
Other than avoiding the problem that David just said.
Right. Well, you're avoiding probate court, which many people have heard about, which is, going through the court to get those assets transitioned.
Is that a big deal? I mean, I thought it'd be fun to go down to probate court, check out, see what's going on, see what the judge is there.
I like helping people through probate court. I like going to probate court, but people don't typically like going to probate court themselves, and they certainly don't like paying an attorney to go to probate court when it's much less expensive to do the pre-planning and do an estate plan.
Well, that's Eric, to answer the question, isn't it accurate to say, Eric, every single person has an estate plan? Yes or no?
You got to turn his microphone off. He's jumping way ahead.
Every person has an estate plan, don't they?
Yes, they do.
Right, and there's 2 types of plans. There's one that you make and you control, or there's another one. What is that?
That's called the state of Michigan intestacy laws. And the legislature has gone ahead and created a distribution plan for you if you haven't done it yourself. And it's based on family relationships. It could be a spouse, children, siblings, parents, nieces and nephews.
I just want you to know I have the acronym because I see it's JAH. D.
Jumping ahead, Dave.
Jump ahead, Dave. Okay, so that's what we got going here. Jump ahead, Dave. It's good point. So,
But what don't-
so if you die without a will or a trust, you die intestate. Where does your money go?
Well, there's a plan for that. That's the intestacy rule. So if you have a spouse, things up to a certain limit go to your spouse. If you've got a spouse and children, they split it to a certain extent that's outlined in the statute.
So if I want all of my estate to go to my spouse and only to my children if my spouse is not then living or when she passes away, and I haven't gotten around to doing an estate plan and I die, I got a problem then?
Well, no. Hey, some people will say to me, that's exactly what I want. I want everything to go to my spouse, then my children, and if I don't have either, to my parents or my siblings. The problem is, even though that plan is outlined for you, to make it happen, you've got to go to probate court. So the probate court judge has to ascertain who your heirs at law are, what your assets are, and then order distributions of everything. And if those children or nieces and nephews or siblings are minors, they're going to get that money when they turn 18. Whereas if you've got children who have financial issues, who maybe aren't the most responsible yet, or who are young, you might want to hold on to those distributions until they reach some future ages. Like in my case, my trust is a third of my kids at 25, a third at 30, a third at 35.
What I was going to say on that is, because I used to do a fair amount of estate planning when I was younger as an attorney, and when I first came out of law school and I was doing an estate plan, I would sit with someone and we'd decide what ages to give the money to the kids in trust, but I was only in my early 30s, and I'd say, oh, give them the money at 21, 30, and 40, or how about 25, 30, and 35, because I figured, why make these poor kids wait? Now, being significantly older than that, we don't need to get into numbers, and having watched myself grow up and make my own mistakes as I've grown up and watch other people, now I'm inclined to say, well, why don't we give them the money, a third at 30, a third at 40, and a third at 50, so that they get a couple second chances after they've bit the apple and made a mistake. Your perceptions change.
Well, the point also is everyone's circumstances are different, and doing an estate plan involves meeting and interviewing and determining what the situation is and how to plan for the situation. I've had people that said, hey, my kids make very good livings, but they're not savers. Let's give them an inheritance when they turn 65 or 70.
That way they'll have a retirement, even though they've made good income while they're living. But now the parents are planning for their kids' retirement. That's probably pretty
right.
Smart.
I think it's
sometimes
important to understand what it means to go to probate court, because in general, when someone thinks of court, they think of fighting and adversarial and bad. All probate court does, not all, but a large portion of it is, it's just a method to transfer title to property when you don't otherwise have an estate plan.
But better to do it without probate court so that you do your own planning. I think that's the whole point of the estate plan. We'll take a break. When we come back, we're going to go on to our next question on estate plans.
I couldn't get out of the car. I couldn't run or exercise. I couldn't work.
Dr. Lewis Radin believes that pain shouldn't have to wait. His Spine Specialist of Michigan is a comprehensive center dedicated to helping you manage pain now. Expect the latest techniques and personalized care. Why suffer another minute?
He's the best. I tell people that he's the one that saved my life.
Make your appointment with Dr. Radin. Call 248-792-9496.
Are you struggling to pay your mortgage? Afraid of foreclosure and the financial mess it can cause? Time is not on your side. Call Alan Stalter, the short sale specialist. For years, Alan has been helping distressed homeowners navigate through the short sale process. His experience will get you out of your home without the credit score damage that follows foreclosure. If you want a fresh start, you need to call Alan Stalter, the short sale specialist, 248-854-3829 or MetroDetroitShortSale.com.
No one ever thinks that a serious injury can happen to them, but it can, and it does. And it can happen to you. And when it does, you need a fighter in that courtroom for you. Call me, Ben Johnson. Automobile accident, police misconduct, medical malpractice, product liability. You know what you're up against, how hard it is to get answers. When all you want is justice, call me, Ben Johnson. Whatever your legal crisis, I will fight for you. Call me today.
If you're retired and in a financial crisis, there is a way out.
It pains me when I see a retired couple exhaust their savings by paying credit card bills and for a home hopelessly underwater.
Thav specializes in helping retired people in financial crisis.
You just can't keep paying until you're broke. You need to address the problem now.
888-235-HELP. That's 888-235-HELP.
We're Thav Gross. Our firm will solve your problem.
Going from hourly to salary seemed like a good career move, but now you're working 60 hours a week instead of 40, and you aren't getting paid any of that extra time. You're stuck, right? Wrong. You can be on salary and still be entitled to overtime. If you've been wrongly denied such pay, you may be entitled to that and more. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Welcome back to the Talk Center. Before we get back to estate planning questions with Eric Quick, I want to go over a couple of announcements. We have a seminar coming up, How to Eliminate Your Debt and Build Wealth, on Tuesday, February 25th, 7 to 8:30 at our offices in Bingham Farms on Telegraph. We got new topics including budgeting issues, as well as how to address this massive student loan problem that so many people are facing. We have an estate planning seminar hosted by Eric Glick, and that is on March 4th, 7 to 8:30 at our offices in Bingham Farms. That's at 12 and F and Telegraph. If you want to sign up for the estate planning seminar, you want to call 888-235-HELP. To sign up for the Eliminate Debt and Build Wealth seminar, you can do that on our websites, thavgross.com or financialcrisistalkcenter.com, or you can also always, of course, call 888-235-HELP. Our websites, we've redone our websites so they're smartphone adapted, so check those out, thavgross.com and Financial Crisis Talk Center. And be sure and try and, if you go to the websites, join and become a Financial Crisis Talk Center member. All you do is you get on our email list. We send you notices of seminars, events, breaking news relative to financial matters, and any legal matters. It's broader than just financial. It's any type of legal issue. All right, now let's kind of switch back to estate planning. I got another question for you, Eric. What are the grassroots alternative issues or decisions that someone has to make when they go about doing an estate plan?
A lot of the times I'll have people come in and they're talking about how, they were told, or a family member was told, you don't need all the fancy schmancy formal legal documents for an estate plan. Just put your son or daughter on your bank account, put your son or daughter on the deed to your house, and those sorts of things.
Well, that way, all right, let's say I put my kid on, let's say I was single and I had a kid and I put my kid's name on the deed as a joint tenant with rights to survivorship. I die, the house goes to the kid, right?
Right. So
what's wrong with that?
Well, so that accomplishes one objective. That accomplishes avoiding probate court, because the house automatically goes to the child. And in your case, it could potentially work easier because you've only got one child. You don't have three children.
Well, suppose
right?
I had three children.
Well, then it's a problem, because then you've got the children fighting. One wants to keep the house, one wants to rent the house, one wants to hold on to it until the market turns around. One wants to live there.
Okay.
Then you've got issues. But even if you've got the one child and you put their name on the deed, you've still got problems, right? Because now if that child who you've put on the house with you, they're a co-owner with you.
Wait, that's a good point. They're not an owner when I die. As soon as I put them on the deed, they're a co-owner.
Right. So now you've exposed your asset, your house, to the creditors of the child.
Suppose they file bankruptcy.
Or get sued, or get divorced.
My kid. Suppose the kid files bankruptcy. Good question, Dave.
Well, let's say this kid is not necessarily that young. Let's say the kid went to college, and you paid for the kid's college, and the kid is wonderful. Wonderful. Mother's Day doesn't buy any mops or any cleaning things, but
no blenders.
No blenders. Father's Day gets tools. And he's got a job. He learns the trade in real estate. He's going to go open his own company. He gets a loan.
He's a great kid. Go on.
He gets a loan, and he has to sign personally for $1 million loan because there's this new development. He's going to build houses, and let's say it's 2007.
He gets sued.
Everything gone. He owes $1 million. He goes to 1-800 bankruptcy, and the guy says, "This is easy. This is easy." we're going to file bankruptcy, we're going to tell the bank to bug off, and you're going to go live your life. But he doesn't ask them, by the way, do you have an interest in your parents' house? Because the kid never thinks of the house as his house.
Then
what
happens,
Eric?
Problems.
Yeah, that's a problem. I mean, if the bankruptcy attorney is aware of it, well, then boom, that's just disqualified the child from filing a bankruptcy, or it forces the sale of the house to pay the creditors.
So mom and dad could have $200,000 of equity in the house. That's their nest egg going forward. They didn't get these crazy mortgages. They stuck by their guns, and all of a sudden they get a letter in the mail a year after the child files for bankruptcy and says, oh, by the way, mom and dad, we're going to sell your house, and we're going to take the equity.
You mean the trustee in bankruptcy?
Trustee sends
well,
a letter.
you have a fight then. You don't necessarily. You've actually handled that same case. You don't. Mom and dad don't necessarily lose the house, but they have a fight on their hands that's going to cost them a lot of money to prove that the putting the son on the deed wasn't intended as a gift. It was just an estate planning issue. But they're going to spend $30,000-$40,000 in legal fees fighting the trustee in the bankruptcy court over the issue. And it's not a guaranteed victory, but it's a guaranteed problem that could be avoided very simply.
Right, and it still could keep the child from filing a bankruptcy, which would be very useful for them.
I want to go on with a different question.
Well, real quick though, another problem is there are negative tax consequences, because now when you put the child on the house, you're making a gift to them, which has gift tax consequences. Plus, their basis in the house is locked in when you've given them the property, the value of the property when that gift is made. So if mom and dad, or you in this case, continue to live there for 30, 40 years, which is the plan,
the house goes up in value,
then you've got appreciation, which is capital gains, and there's capital gains tax consequences, versus if you would have just left that house to your son through a trust, they get the stepped-up basis, stepped up to date of death value.
So that means when I die, if I hold the house and when I die it's worth $500,000 and then I leave it to them, their basis is then $500,000 unless they sell it for more than $500,000. They have no tax. However, if I gift it to them 20 years, or if I put them on half the house 20 years earlier when it's worth $200,000, then when I die, they get a stepped-up basis on half the house for my half, but on the other half, their basis is one half of the value that existed at the time of the gift, which if we said it was $200,000 would be $100,000 on that half, and they'd be looking at a capital gains problem.
Ken, there's another
when they sell the property.
There's another critical problem if they do that. If mom and dad own the house and they're husband and wife, and they add a third person, what did they just do?
It also destroys the tenants by the entireties protection, which is only available to husbands and wives, and it protects property from creditors of one, not both.
Good point. So next question, because I want to get through them. How does gifting work? What's this? I hear all this stuff about gifting, that I can gift my kids X and Y. Is there a tax for gifting, and what's the amount that I can gift? And why would I gift?
Well, there's two ways you can. I mean, you can always make a gift of whatever you want to, but under the current law, you're allowed to gift up to $14,000 per year. So husband and wife can gift $28,000 to anyone they want to, family member or not, or there's a lifetime exclusion as well.
So the benefit there is if you have a taxable estate, by gifting while you're alive, you reduce the amount of your taxable estate. So when you die, you minimize any potential estate tax consequences.
Correct.
All right, we're going to take a break. When we come back, I've got a couple more questions for Eric Lick on estate planning. We'll be back.
You like your job. What you don't like is the way your boss has been treating you. He's making comments about how you look instead of your work, and he's been touching you inappropriately. If you complain, is he allowed to fire you? Absolutely not. Unwelcome sexual comments, advances, and contact are illegal in the workplace. Make him pay. Gold Star Law is here to help you through your employment law problem, whatever it is.
Gold Star Law, protecting employees' rights. Call 1-800-WAGES-10 for a free consultation today.
Every family has the family meeting, and we all know what that means. Dad's got dementia. What are we going to do? What's the care plan that the family has in place? Usually they don't, or they struggle with a care plan. When you go home tonight and you talk to your tax person and you talk to your financial person, say, what's the plan that you have in place? And as soon as they don't give you an answer, give me a call, because I can do it for you.
Double action. Shooting Center and Gun Shop for the largest selection of guns, accessories, and ammunition. Double Action is your only pro gun shop. And now you can train with the best in our basic CCW course with the most comprehensive curriculum, the best resources, and most accomplished staff. Don't be fooled by cheap imitations. Double Action is the only place to get your CCW or renewal. Double Action. We're on DeQuinder and Madison Heights.
Do you have tax problems, unfiled returns? Facing levies on wages in your property? You need an expert, not a cartoon character or salesman. Thav Gross is your solution.
You need to look at the big picture. That's what we do. We develop a plan that's right for you.
I had major tax problems. I didn't know what to do.
You need to address the problem now. Call the experts.
We're Thav Gross. Our firm will solve your problem.
888-235-HELP. That's 888-235-HELP.
All right, welcome back. We're talking about estate planning questions. I want to mention our sponsors, and then I want to come back to what are the elements of an estate plan. But I got one little thing I want to throw over to Jenny before we do that. But on our sponsors, I want to thank Ben Johnson Law, Gold Star Law, Samasco Law, Double Action Shooting Range and Gun Shop, Spine Specialists of Michigan, Elite REO Services, Alan Stalter, short sales specialist. We use Alan all the time, working together on short sales. And coming on board, Cardiology Associates of Michigan, great cardiologists covering East Side. Jenny, you have a young baby.
Yes.
If something, perish the thought, but something happened to you and John, what provisions have you made for who takes care of Jacob?
It's all been done.
Because you have in your will, there's a guardianship provision, correct?
Correct.
And that's, Eric, that's where you insert the provision to cover guardianship of your children?
Right. If something happens to the guardians.
I want to see your brother do the diapers. That's what I want to see. I would pay to see that.
Ever happen?
If I had $1 million, if I had $100 for every young couple that has a baby and doesn't even have a will identifying guardianship for their children, I'd be totally retired, correct?
Well, and David mentioned how relatively easy going through probate court is. I disagree to some extent. And this is a situation where, if you don't have a guardianship appointment, that's something people take seriously. You want similar parenting styles, that whole thing. And if you don't have a guardian specified, you don't know who's running the probate court to be appointed that guardian and who's ultimately going to be appointed.
Absolutely.
You want to have the opportunity to name your key people.
Yeah.
And there's a difference between
critically
the
important issue.
There's a difference between the guardianship and who's going to handle finances as well.
That becomes a conservator, or that becomes you can have different. You can have a trustee that takes care of that. Which brings us to the question: what's the typical estate plan? What's the garden variety estate plan that most people should have?
Well,
what's it composed of?
The four main documents would be a revocable living trust, a last will and testament, a financial power of attorney, and a power of attorney for health care or a patient advocate designation, or what some people think of as living wills.
All right, quick sub questions on this because we're getting short of time. So I want my answer. I want to get answers to my questions.
Okay.
All right. Why a will and a trust?
Well, typically a trust is designed to avoid probate court. So if you have any assets that would be going to probate court, we don't want that to happen. We want to use a trust. A trust is a separate entity, separate from the person that creates it. And it's got perpetual life. So as long as you're alive and well, you're in charge of everything in your trust. But if you're not so alive or not so well, your successor trustee steps in.
So is it safe to summarize that the benefit of the trust is you can designate where you want your assets to go and control them upon death, but you avoid probate by having those assets in the trust before you die?
Yes.
And also, it's a document that you can designate for who takes over and runs your estate while you're living if you're incapacitated.
Exactly.
And it keeps your personal affairs private. Probate is a public forum. And it also, you circumvent probate fees and inventory fees and the length and time of dealing with probate.
All right, power of attorney. What do we use that for?
Well, a financial power of attorney is just appointing someone to handle all your financial affairs for you if you become unable to do that yourself. So it's to pay bills, to write checks, to apply for government benefits, to deal with the nursing home, anything that you may have to do, to mortgage property, to sell real estate, to buy real estate, anything. You can't do it yourself. You need to appoint someone to do it for you, or else someone's going to be running a probate court to be appointed a conservator to do it.
Next question. I did an estate plan 14 years ago. Is that good? Do I need to update it? Or can I just, if I did it 14 years ago, why do I have to revisit this thing? My wife, Bonnie, always says to me, I don't like to redo things. I don't want to redo rooms in the house. Do I have to redo my estate plan?
It depends. Sometimes you can get a long time out of your estate plan. Sometimes you need to update them because we have no control over what happens with the law. So over the past 14 years, a lot of things have happened. In terms of the tax laws, we had, what they call the evil Bush tax cuts, ETEGRA, the Economic Growth and Tax Relief Reconciliation Act of 2001. And we went through all that, and that's gone. That's replaced now with the new law. We had HIPAA, the Health Insurance Portability and Accountability Act, which was a healthcare privacy law that came into effect in 2003.
I think the world's become one big acronym is what it's really come down to. I follow what you're saying in that. What are typical misconceptions about estate planning?
Well, the biggest misconception I hear is people think that they don't have to worry about probate court unless their estate is worth over $600,000. And I think that relates to the law before ETEGRA, and there's confusion about whether you have to pay an estate tax or not. Whether or not you go to probate court has nothing to do with how much you have. It has to do with how your assets are owned. If I have an account in my name, even if it's only $1,000 in it, if something happens to me, it's got nowhere to go. My wife can't go to the bank and say, give me Eric's $1,000. They can't do that. So she has to go to probate court. So avoiding probate court is important no matter how much you have.
Ken, we would be remiss if we didn't identify, I want you to talk quickly about it, Eric,
We don't have time.
a toxic asset that you don't want in your trust.
Okay, yeah, right. So a lot of times we're talking about underwater homes, and the old rules.
Good point, David.
The old rules were you want to have everything in your trust, everything flow through your trust, and one of the largest assets people had was their home. The kids would sell it; they'd split the proceeds.
So if you've got an underwater home in your estate, and the bank will assert a claim for the deficiency.
Right. Whether
So
you've
you
got a
need to address
trust,
it.
a will, whether you've got nothing, the rule is debts have to be paid out of the assets.
We got to get out. All right,
Okay.
Last question, because we're out of time. What is the typical cost of an estate plan? Is it like $5,000?
It ranges. You could easily expect to see $2,500 to $4,000. We typically have very fair, reasonable prices. We start at $1,500 for estate plans, a full, comprehensive estate plan with all the meetings.
We're out of time, but I'm going to tell you right now, if you call Eric up and ask for an appointment for an estate plan and you mention the word questions, which is the word of the day, there's a $250 discount waiting for you. This is I'm just springing this on Eric now. No, don't mention the word questions. No soup for you. Have a great week. We'll be back next week with the Financial Crisis Talk Center. Thanks for listening.